Hello and welcome everybody. I'm Phil Grove and welcome to the Dodd-Frank Federal Reserve Owner Finance Legislation webinar. And boy, was that a mouthful. We are here for a very special event on a content-only webinar to discuss recent regulations that affect us as real estate investors. And this is such an important topic that I invited to join me. Let me advance the slide here. My own attorney, Mark Turok. And Mark Turok is actually the nation's leading authority on owner financing and, well, just about any kind of non-traditional real estate investing. So if you don't need a loan, but you need to close a deal and basically do anything that real estate investors do, Mark is your man and he is the authority on such things. So welcome and thank you for joining us, Mark.
Thanks, Phil. Pleasure to be here.
And Mark, you know, it feels like we are under assault as real estate investors. Every time we turn around, it feels like the government is coming up with some new law or rule or regulation or statute or whatever. And a lot of times these things are, not even necessarily targeting us as real estate investors, but there always seem to be these unintended consequences that come from these different rules and regulations. So is real estate investing under assault?
Well, it certainly feels like real estate investing is under assault, but as you say, I do think it's the result of unintended consequences with the focus of the federal government on the housing debacle that we've had in the country and the housing slump. They've tried to enact rules but do not know that the real estate investors are out there, or if they do know, they don't care. So I don't think these laws have been aimed at the real estate investors, but certainly the SAFE Act and the MARS regulations and now Dodd-Frank certainly will have an effect on how investors do their business.
Well, you know, every time one of these new regulations comes along, I hear this big, heavy sigh across the industry, the real estate investor industry, and everybody's immediate reaction is, oh my gosh, they've outlawed owner financing or they've outlawed investing in real estate. And, you know, what happens is, we have to all take a deep breath and just make sure that we're doing things the right way. So, you know, has anybody outlawed being a real estate investor?
No, they haven't. And I'll tell you, though, that we call it, when you do government relations, we call it the Chicken Little syndrome. And the sky is always falling with any legislation that's proposed. And it usually turns out that it's not that dramatic. And life as we know it will continue to go on. In this particular case, I think that's the case as well. I think life will go on with this, and certainly we will be able to do real estate investing pretty much the way we want to do it.
Yeah, I mean, and that's usually the case. You just have to, though, be aware of what the most recent laws and regulations are, and you have to make sure that you're following the proper procedures and you have the proper disclaimers and the proper licensing, and you're working with people who know what the heck they're doing. And as long as, it's been my experience, you're working with people that know what the heck they're doing, you know, there's no problem being a real estate investor. It's just when a cowboy or maverick runs out and doesn't know what they're doing and doesn't follow the rules that they can tend to get into trouble.
I think that's true, and very true. Real estate investing has always been if you do it right, there won't be any problems, and I think that that's true. In fact, you can trace most of our anti-real estate investing rules back to investors who were either doing it dishonestly or were doing it in violation of some other statute.
Or just as back to unintended consequences from things that had nothing to do with us but end up affecting us.
Exactly.
So Mark, I want to go ahead and get you into your presentation. You're going to tell us about some of these recent legislations and regulations, and basically tell us how to safely invest in real estate regardless of these. Is that right?
Absolutely. That's right, Phil.
All right. Well, go ahead. Let me turn it over to you.
Okay. Well, the first thing is, of course, as a lawyer, I have to make sure that Everything's done legally, so we've provided a disclaimer. If you're not one of my clients now, you can't sue me for anything that I say here tonight. You possibly could sue me if you were one of my clients, but not for this presentation. We're just going to provide a brief overview of the Act and what it does and how it works.
Alrighty.
So I call this government shenanigans again, dealing with the Dodd-Frank Wall Street Reform and Consumer Protection Act and regulations. The Dodd-Frank Wall Street Reform and Consumer Protection Act, it was one of those large bills passed in the frenzy of Congress, and it turns out to be 848 pages on a wide range of topics, such as establishing a federal insurance office, establishing financial stability oversight committee. It dealt with bank and savings and loan association holding companies. It dealt with the swap markets, the investor protections, the Bureau of Consumer Financial Protection, TARP, and all those kinds of things. It was signed in July 2010 by President Obama. And for our purposes, our particular purposes, it amends the Truth in Lending Act to essentially prohibit creditors from making loans without regard to the consumer's ability to repay them. It's the lender's fault, and the lender has to protect the consumers out there.
So clearly this was a very well-intended law.
Well, I guess that depends a little bit on your view of personal responsibility, but yeah, I imagine that there were some who were confused or cheated out of something, but I'm a firm believer in professional responsibility. So I would be against this law, but it is law, and so we have to deal with it. The Act starts off, and the main part of it really starts off, and this is all one sentence. What you see before us. Obviously, this was written by lawyers, and it took me probably about 15 minutes to find the verb and the subject in this. But essentially, it says that a creditor has to make a reasonable and good faith determination based upon verified and documented information that the borrower can repay the loan. The regulation has been proposed by the Federal Reserve Board to be adopted by the Consumer Financial Protection Bureau when it came into existence on July 21st, 2011. The Federal Reserve Board proposed the regulations, and then they gave it over to the Consumer Financial Protection Bureau to actually do some of the enforcement. The proposed regulations require that before making a loan on residential property, that a creditor consider and verify income, employment, monthly payment, any monthly payment on simultaneous loans, the monthly payment on mortgage-related charges, that would be something like taxes and insurance and mortgage insurance and flood insurance and everything that normally goes into the loan. You're also supposed to consider the current debt of the debtor, the debt-to-income ratio, and the credit history.
Now, Mark, are there specific standards for each one of these things, or just you have to consider it?
No. Actually, there are. You have to understand that the proposed act is 117 pages of very small print and deals with a lot of how these things have to be figured. What goes into a calculation as far as monthly payment? How do you handle balloon loans, stepped rate loans, adjustable rate loans, all those kinds of things. And actually in the proposed regulations, they have various alternatives that they have invited comment on. So this regulation is going to take a while before it actually gets enacted or finalized. But it is a bunch of a whole lot of calculations and things like that.
All right.
So now there is one main thing or one main or here, or one main exemption, or whatever you want to call it, and that's that the proposed regulations also allow you to write or originate a qualified mortgage or do certain loans in rural or underserved areas. Now, we're not going to talk about the rural or underserved areas, but if you're in the country and in a rural area, you may want to consider that aspect of your real estate investing. What we're going to do is we're going to focus a little bit on what a qualified loan is. The reason being is for a qualified loan, you don't have to verify all of those other factors. The board, in determining a qualified loan, it has proposed two alternatives for dealing with the qualified loan. The Act says you either have to verify these 8 factors or write a qualified loan. The first alternative that the board has asked that for comments on would establish a safe harbor from the requirements of having to verify and consider the borrower's ability to repay. The second establishes a presumption of compliance that could be rebutted by the debtor for a qualified loan. Obviously, and the board noted this in their comments, the first would appear to be more what the law is saying and more what they're trying to do. And the board also noted that if they made it a presumption of compliance, it would appear that what would happen would be that no one would write a qualified loan. What they would do would be, because they would be concerned with being sued, they would just comply with all of the verification standards that we talked about previously. I think, if I was a betting man, I would bet that there's going to be a safe harbor and not a presumption here, and that would certainly be what we hope, although we could deal with it either way.
So when you say you could deal with it either way, this legislation has not yet been enacted. These regulations have not been yet enacted, so you're just going forward here as if they have.
Yes. We've looked at these and we've studied them, and so we've put together some processes, actually, which I'll talk about in a little bit, as to how to address the issues presented by this law, and I think the investors are going to be fairly satisfied with those.
So let me understand where we are so far. When you create a loan, you have to take all of those things under consideration, or it has to be a qualified loan.
That's correct.
And now we're going to define what that means.
Exactly, yes. The proposed regulations say that a qualified loan is a loan that does not contain negative amortization, doesn't contain interest-only payments, doesn't have a balloon payment, and it doesn't have a term greater than 30 years. On this loan, the total points and fees can exceed 3% of the total loan amount, and you still do have to verify the income and assets, and there are some reduced standards or some ways that you do that. You can certainly do it verbally, that the person is working. You can do it with tax returns, and you can do it with some other things that people use. So the qualified loan actually is almost all of what we see from the investors when we're closing the deals. About 99% of the wraparound mortgages that we see meet the definition of a qualified loan. Typically, they're between 9 and 10.5%. They're for 30 years or less. They're fully amortizing. There's no prepayment penalty, and usually there's no balloon. Now, there are some requirements with respect to balloon loans, but they are going to probably go away with this legislation, so that can cause a bit of a problem for folks.
Okay, and Mark, again, just to make sure we are all on the same page here, we think that this is primarily going to pertain to owner financing, and specifically, very often we're doing wraparound mortgages, or what I like to call mortgage payment assignment, where we're essentially giving a mortgage that an existing buyer and owner has to a new buyer. we're reassigning their mortgage payments, or we're wrapping the loan with a new loan and then giving that loan to the buyer. And those are the very popular forms of owner financing these days. And this is likely to, I guess, regulate the people that are using that very popular strategy.
Yes, the proposed regulations, as they were proposed, don't single out individuals as writing subject to or loans like that. I would say, though, that in the situation where you're merely assigning the payments on an existing loan, that wouldn't have to be qualified, nor would you have to verify all of the items, the 8 items that to consider the quote borrower's ability to repay the loan. That's a loan that's already in place, and this entire regulation and law is designed for the at the conception or the consummation of the loan. In fact, they actually use that word, the consummation of the loan, kind of like a marriage, I guess. But
is that the same thing as the origination of the loan?
Yeah, that's the same thing as the origination of the loan and the signing of the paperwork. So that's. I don't think you have an issue with loans that are merely being assumed or taken over by someone. It would, however, apply when you do a wraparound loan with different terms than what had occurred previously.
Alrighty.
Now, one other thing in the regulations that some investors might be interested in is it talks about prepayment penalties on all loans. They are severely restricting prepayment penalties on the loans that investors are going to write, or anyone is going to write. They are basically saying that a prepayment penalty cannot be offered and exist for 3 years. You can only do it for the first 3 years, and it can't exceed 3% of the amount that's being paid off. Their example was that if you have a $100,000 loan and somebody pays $20,000 on that loan, the prepayment penalty can't exceed $600. So it's the 3% of the amount that's being paid off as a prepayment penalty.
Well, this is something I actually like.
Okay.
I mean, we've always had a pet peeve about prepayment penalties. As an investor, of course, it doesn't really affect me much because I've never done a deal where I put a prepayment penalty into the deal. But as a buyer, I simply like this.
It does affect some of my clients that use their IRA money to loan money to other people in their housing needs. They're looking for a guaranteed return, or at least an almost guaranteed return, and they're not real happy when the loan gets paid off early and their IRA has to go out and find something else to invest in. But the big kicker with the prepayment penalty, though, is that if you're going to have any kind of prepayment penalty, you must also offer a different loan, a similar loan but different, without a prepayment penalty. Normally, they anticipate that if you have a prepayment penalty at an interest rate of 6% and you want to have a prepayment penalty, you're going to have to offer a loan with the same terms, the 30 days or 30 years and no balloon, etc. But that you could increase the interest rate at that point and allow the consumer the opportunity to pay off the loan. But so that's in my opinion, at least in 99.9% of the situations, the prepayment penalties are dead. This may seem a little odd as to why I'm going into the Federal SAFE Act. But there are issues between the interplay of the SAFE Act and the Dodd-Frank proposed regulations, the Dodd-Frank Act and the proposed regulations on Dodd-Frank. So if I can back up just a minute, we have in every state what they call the SAFE Act, the Secure and Fair Enforcement for Mortgage Licensing Act. Essentially, that says an individual may not engage in the business of a loan originator without first registering as a loan originator or be licensed as a state licensed loan originator. So, what does that mean? Well, an individual who takes a loan application or offers or negotiates the terms of a residential mortgage loan, such as seller financing, for compensation. So, all of the investors with respect to doing wraparound loans would be subject and are subject to the SAFE Act. Note that a residential mortgage loan is a loan primarily for personal, family, or household use secured by a mortgage or deed of trust. That would be when you're selling, not when you're buying. You're actually buying a commercial loan. It's not a personal, family, or household use. So you're not covered when you buy. You will be covered, however, when you sell it to the end buyer. And of course, there are exemptions under the SAFE Act. And my personal favorite is the exemption for attorneys. An attorney has can, as part of the representation of a client, can take can do the offer and negotiation of financing terms. So, if you look at kind of a conclusion, under the SAFE Act, a person can't take an application or discuss the terms, offer, or negotiate a residential loan to the end buyer. Our process has been that we do not have our sellers or the investors discussing financing at all. Instead, they determine, or they ask the people how much they can afford per month and how much they can afford down, and then we figure out what loans they might qualify for or what loans could be written on a wraparound basis to accomplish that. And we take that on in our office. It goes out on our letterhead. We talk with the investor. We figure it out, but it goes out on our letterhead, and so we're actually making the formal offer of financing.
So Mark, just to make sure I understand this, because you're an attorney, you're essentially exempt from the SAFE Act, and you are able to, on your client's behalf, negotiate the terms of a loan. So when you're helping somebody close a deal, as an attorney, you can basically negotiate the terms of that wrap loan or any other kind of loan that's being created because of your status as an attorney.
Correct, yes. When I represent my clients, I can do that on behalf of my clients.
Okay, so that's the workaround, essentially, if a real estate investor wants to do owner financing involving wrap mortgages.
Exactly.
Okay.
What we have, though, is in the exemption, we are not allowed to take an application. We can negotiate the terms, but we can't, as an attorney, take an application. If we do both of those things, then we have to be licensed as a residential loan mortgage officer.
Loan originator.
RMLO is for short, is what it is. So that creates a bit of a problem with the Dodd-Frank, because if you couple Dodd-Frank with the SAFE Act, we still need to take an application and take steps to verify employment and assets, even if we're writing a qualified loan. But you can't do that without help from licensed people. A bit on the proposed regulations. The comments were due July 22nd, 2011. The proposal itself sought comments on more areas and alternatives to consider than I've ever seen. So this is going to take quite a while before it's adopted. It's a brand new agency who doesn't have their feet on the ground yet. They don't even have a confirmed head of the agency yet. So it's going to be a while before they get their act together. It's going to be a while for them to sift through all of the comments that were made, and it's going to take a while for them to make a decision. So we're probably looking, if this were to happen in 6 months, it would be the quickest it would send shockwaves that the government was able to work that fast.
Margaret, let me make a comment on this, because I know that when the comments were due on July 22nd, throughout the investor community, the word on the street was, oh my gosh, owner financing is going to become illegal on July 22nd. But in reality, that was just the deadline for essentially filing your opinions and comments on these proposed regulations. Now we're in the process of the government consuming those opinions and comments and formulating them into regulations, and presumably they're going to maybe soften or adopt or modify the regulations based on the feedback they got.
Absolutely. I've actually known about this since it passed, and never brought it up, because the Dodd-Frank Act itself says that they have to adopt regulations, and I knew that regulations, quite frankly, I wouldn't look for anything from as far as final regulations probably for a year, and I would not be surprised if it takes 2 years to get there. So we're still operating under the old rules, but I don't think it's certainly not imminent, and of course we'll have more info for everybody as the regulations progress through the approval process.
But certainly we need to understand, even though this has not yet been enacted, and it's not probably going to be enacted right away, it probably will be enacted in some way, shape, or form. So you're going to tell us how we're still going to be in business as this thing gets put into law, correct?
Right, yes. What we're doing for investors, and by the way, we only represent investors. That's been our main purpose. That's all we do. I often say I suck as a divorce lawyer, so don't give me your divorce work. I don't do that well. But we're pretty good at non-traditional closings and things. So what we've decided to do, and everybody in our firm agrees 100% with this, is we're going to take on the additional burden of, we already take it on with respect to the SAFE Act, we're going to take on the burden of the new proposed regulations and obtain licenses as residential loan mortgage originators, so that the process is going to be similar to our current process with the SAFE Act. That is, you won't be taking the application. What we'll be doing is, when we send out the formal offer of financing, or shortly before that, we'll be sending out an application to the potential buyer of the property. We'll have them fill it out. We'll do some of the verification. We'll verify income and assets. And then we'll issue the formal offer of financing, or finalize the loan terms, so that the investors don't have to do that they don't have to undertake that burden, and they can continue to do what they do best, which is find houses, buy houses, and sell houses.
So just so I understand again, what you're saying is, to be compliant with the proposed new regulations, somebody in the deal has to be a licensed mortgage loan originator, and the investors are going to have an option. Either they have to get that license themselves,
right,
or they have to go hire a separate, basically licensed loan and mortgage originator, and then another attorney or title company to close the deal.
Right.
And you're saying the other option, which I agree is probably the best option yet, is if you have an attorney that is also a licensed mortgage loan originator, then you get one-stop shopping, and your law firm is actually doing that.
Yes, that's absolutely correct. And the other benefit that we're gonna find from that is that the standards as to the ability to pay under the proposed regulations are either the standards established by the government or by non-government standards. Well, the more people that we have that we're receiving applications and loan applications, the better we can put together standards that will cover what the investors want to do. And they're talking about standards which are used in more than just a minimal amount of cases. So in that way, we can be pretty proactive. And if they object, well, I mean, the answer is, what we're using the standards of the Torok law firm, who has done 1,000 of these, and so that I think is another benefit of what we're doing. Obviously, we will provide an opinion once the regs are approved. and we'll let the investors know what options they have. So our conclusion in this is that we are very confident, even if the regs are adopted as they're written, AMPS, in particular, Phil's program, either assigning the mortgage payments or doing a wrap, will remain a completely viable technique in the marketplace, and quite frankly is about the only way that other than super stellar A credit W-2 employee folks with 20% down are going to be able to buy houses. So we're very confident with that.
And Mark, this is a content-only webinar. Not everybody knows. AMPS is the Assignment of Mortgage Payment System. It's a training program that I teach. We're not advertising that on this website, although we're mentioning it. But you're just saying that process. It's basically learning how to invest subject to, like I teach and other people teach. That process is legal if it's implemented correctly with the proper licensing, etc. And you anticipate that buying and selling houses this way will continue to be, perfectly legal going forward, even as and if and when these regulations are adopted. But you just have to make sure you have the, again, proper licensing and the proper disclaimers, proper truth in lending. You do it right.
Yeah, absolutely. It's very similar to everything. You can drive a car correctly, or you can drive it in the other lane, and there are consequences for that. So as long as you're doing it correctly with the right team behind you and people that know what they're doing on your power team, there isn't going to be a problem with this. I will say that in fact, and I know, I just wanted to point this out, there are always unintended consequences from laws that are made. First of all, in this one, I prefer to look at the glass as being 99% full, more than half full, rather than a little bit empty, because what the feds are doing here is that they're tightening up lending requirements, which is going to mean that people can't get loans, and if they can't get loans, they can't sell nobody can sell a house. The only way they're going to be able to sell, in a lot of instances, is going to be through either the AMPS program or the subject to, and you have to be able to do that right. The other unintended...
So that's a good thing for real estate investors, because we've got a solution to the problem. And what I always tell people is, look, the biggest rewards go to the people who solve the big problems in the big times of need. So you can either see this as a huge problem. It is going to be a problem for many, because the last thing we need, is less lending out there. But that also creates a huge opportunity for those people that know how to solve the problem by providing loans in the form of owner financing and wraps.
Absolutely. This is going to practically guarantee that subject to is going to be around for 20 or 30 or 40 or 50 years until they free up lending, and we go back to those days where all you had to do was fog a mirror, which of course everybody figures we're not going to do. But the other unintended consequence that I wanted to note is that the investors that figure out a solution, and I salute you for listening tonight, have a competitive advantage over those that don't. And those that are listening to the pundits and saying life as we know it ended on July 22nd are simply incorrect. And those investors that remain and have figured out the solutions wind up even getting a bigger, larger and larger piece of the pie.
Well, Mark, thank you so much, and that was amazing. I really appreciate you spending some time with us today, and giving us the bottom line on this law. I know that everybody's been interested. I know this is a huge relief to me. When I heard about this Dodd-Frank Federal Reserve regulation, I can't tell you, I probably got 50 different emails from different investors saying the sky is falling, it's the end of owner finance, etc. I've heard that before, and thank you so much. for reading the, what was it, 800 pages of...
well, the Act is 848 pages, and
Yes.
the regulation is 117. I had to, and it's very dry, and it's very boring, and it took me several nights to get through it because I kept falling asleep. So,
Well, thank you so much
My
for
pleasure.
doing that for me and really for everybody out there. I know I feel incredibly relieved. Now, that being said, this is going to change things a little bit. And I think if I'm going to, let me make sure I summarize things. I think the biggest deal here is, to continue to be able to do things like owner finance, wraparound mortgage, like I teach in my training program and other people do as well, to be able to do that. Now you need essentially both an attorney and a licensed mortgage loan originator, or you need an attorney that is a licensed loan mortgage originator. Is that correct?
yes, you could probably get by with a licensed residential loan mortgage originator and a title company.
Right.
But every title company needs a lawyer to do the documents.
Every
anyway.
state's a little different. In some cases, it's harder and harder to find title companies, for example, that will close, wraps and subject tos anyway. So,
Absolutely.
I know personally, I use attorneys all the time. In fact, I use you all the time to close all of my deals,
Right.
and I really appreciate that. So let me review a couple of other questions, and we've got some questions coming in as well. And I just want to make sure everybody, including myself, understands this in its entirety. The one thing that was a little bit of a surprise to me is that it looks like putting balloon terms on these wraparound mortgages, now that may go away. Is that correct?
Yeah, on a qualified mortgage, that will go away. So if you don't want to verify income and assets and debt to income ratios and credit report and credit scores and things like that, then you're not going to be able to write a balloon loan.
Right, but I mean, as real estate investors, we're generally not qualifying the loan to that degree when we're doing owner financing. So,
Right.
from a practical perspective,
yes, that's
I
correct.
think the thing that changes the most for me is I can't do balloons anymore for the types of owner finance deals that I have been doing. Now, that's not the end of the world. In fact, I generally have been recommending to sellers that I don't suggest that we put balloons in the terms because it can set the buyer up for failure. So I don't really like to put together a deal that puts impediments in the buyer's way. But there are certainly great applications and uses for balloons, and I'm going to feel a little badly that that's going to be a less available tool in the future. But, I don't see that as slowing my business down at all, because if somebody asks for that, then I'll just simply say, can't do it anymore.
Can't do it because of the law. Although it's not entirely correct, there are some ways to do balloon loans, and it's contained in about 15 pages on the proposed regulations. But let's not get too complicated here. It is easier to say we're not going to do a balloon rather than do a balloon with a automatic extender with the consumer at the consumer's option, et cetera, et cetera. So it is safer to say that you can't do a balloon loan. And if you want to do a balloon, you need somebody to help.
Okay, if I really want a balloon, I'm going to call you,
That's
and you're
right.
going to go through those other 50 pages of regulations to make sure we do it right.
Yeah.
The other thing that was interesting to me is, in your opinion, if we do what I call a pure mortgage payment assignment, where we simply get the property under contract subject to the existing financing and then assign that contract or wholesale that to an end buyer in exchange for a fee, in that pure mortgage payment assignment transaction, we're not actually originating a new loan. So in your opinion, that would be exempt from these new regulations as well.
Yes, yeah. They're talking about creating a new loan or originating a new loan, and it's at the time the papers are signed, the consummation of the loan, which occurred previously in this particular situation. So it doesn't apply where you're just assuming a loan or assuming payments or assigning payments. It's really applies when you're doing a wraparound or just a pure owner finance deal.
Okay. And I think that's useful and helpful. And I'm actually I teach in my AMPS program, for example, how to do the mortgage payment assignment process. But I usually tell my students, once you learn that, add the extra step of raising the payment and wrapping the loan, and it's actually more profitable. And most of my students close most, if not all, of their deals as wraps because they're more lucrative to do that. But knowing that the mortgage payment assignment is probably exempt from this is interesting and helpful to know.
Right.
Another question that I know a lot of people have is, look, I don't want to be an attorney. Sorry, I'm glad you are, but I had other aspirations.
You actually have friends. Attorneys don't have friends. I understand that, yes.
Well, I'm your friend, Mark.
Okay. Well, that's how we know you're lying, Phil. Attorneys don't have friends.
But seriously, look, I just want to close the deal. Look, I'm good at doing marketing and finding buyers and sellers, and I just want to do deals. I really don't want to have to figure out how to, originate loans and negotiate terms and, do all the things you were talking about. Can I just, hand you a contract and say, you do it?
Well, actually, our process is very much like that. With our contracts that are on REI Matcher or through our website, there are a couple of provisions there, and we can go through the contracts. But quite frankly, there's nothing that you can do on the contract that we can't fix before closing. And our process is fairly simple. Our goal was to make it as easy for the investors to take care of the legal papering up of a deal. So what we really ask is that you send us the contract, answer questions when we ask, sign when we ask, and then cash your checks. We've got a lot of stuff that we do behind the scenes, but we've got extremely competent staff to do it, and we know what the law is, and it goes into our system, and we process it that way. So there's quite a bit that goes on behind the scenes, but for the investor, all we want you to do, quite frankly, is to answer questions, sign, and cash your checks. In fact, in most instances, it will work much smoother if you don't help us. Okay.
Well, and I appreciate that. And you mentioned these contracts. Yeah, I know in my training program we have these contracts that your law firm developed, and you were very gracious because you actually developed a separate set of law contracts for each of the 50 states, which is really amazing. Used to be that if you wanted to do this kind of a deal, you would have to take your state contract and kind of staple it to a subject to addendum and some different disclosures and some different truth in lending documents, and you'd end up with this kind of Frankenstein document. And for a lot of investors, especially new investors, that was a very overwhelming process to assemble all that stuff. And you've got a very simple contract, and there's a different version of it for each state. You just fill out that contract and send it in. Your law firm can close those deals. I love the fact that you've got the licensed loan origination and you're the law firm and title company and loan servicing. So you're truly one-stop shopping. We just send you the contract because that's all I want to do. I just want to fill out a contract and send it in. I don't really want to have to go out and find all of these different experts and licensed authorities, and I don't really want to have to assemble all this junk on my own. I just want it simple, and I just want kind of the one-stop shop.
And that's what we were trying to provide. We are a bit altruistic in that we wanted to provide that to the investors, but there's also a selfish side on that as well. We got tired of answering the questions, which parts of which addendums and which contracts and which attachments and do I use this or do I use that page or document or this form or that form. We got tired of answering those questions, so what we did was we made one really good contract, and now if you ask us which form to use, we'll say, well, use the one for your state. If you're in Illinois, use the Illinois contract that we have. Use the California if the property's in California.
Well, Mark, let me go ahead and take a couple of questions from online. Do you have a few more minutes to spend with us?
Sure.
Okay. We have a question here. It says, in your opinion, what's the best strategy for investing in real estate right now?
Quite frankly, I have examined. I probably have more gurus courses than any other, and yes, I know that that I often speak at your events. But what most people don't realize is that I actually am there on my own nickel. I'm not being paid to be there. In fact, it costs me airfare and hotel and food and all that stuff to be there. And to me, my highest